Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And today our group are going to present about the case of Chye versus Bei Zhan restaurant Sdn Bhd. And this is our team. Our team consists of 4 members, which is brother Ahnaf Al-Qais, brother Aiman Izdihar, and also me, brother Faiz and Shah, and also brother Ahmad Zaidan Khairi. Next, we are going into the introductions of this case. The case name is Chye versus Bei Zhan restaurant Sdn Bhd. And the full citations of this case was Chye versus Bei Zhan restaurant Sdn Bhd 2023 MLJU 375. And the Malaysian Law Journal that reported this was Malaysian Law Journal Unreported. And the name of the judge is Muhammad Razi Abdul Hamid J. And the level of the court is High Court, or specifically High Court of Malacca. And the area of law involved is civil law, specifically on tort of negligence. And in addition, this case also discussed on the applications of contributory negligence as defenses. And this case was very important for us to show the applications of negligence in Malaysian cases and how negligence cases depends on the circumstantial evidence, and the standard of duty of care of a reasonable man can vary depends on its closeness of a relationship. This case also will show the applications of contributory negligence in the decided cases if the respondent found liable for the negligence. Next, we are going into the mature facts of the case. This case is an appeal cases involving Chye as the appellant and Bei Zhan restaurant Sdn Bhd as the respondent. Chye, the appellant who was an invitee to that restaurant, has fallen due to uneven height of the stairs rises, and this has caused the appellant to suffer physical injuries. The appellant also claims that the respondent has failed to provide a proper warning sign, and the appellant appealed to the High Court on the ground that the magistrate has failed to appreciate defendant's admissions that the rises was uneven. And the appellant also appeals to the court to set aside the magistrate decisions on liability and claim for damages for the physical injuries that he suffers. However, the court also stated that he has its own part of liability, or known as contributory negligence, as he has the knowledge and the familiarities that the stairs were uneven.
So now we are going to take a look at the counsel argument. So first, from the side of the plaintiff, he argued that he fell because of the unevenness of the height between the rises of the stairs, and then there was no warning or colored strip affixed to the stairs to warn the users of the unevenness of the stairs, and C, there was a failure by the defendant to generally maintain the safety of the stairs, and last but not least, there was a failure by the defendant to generally provide a safe environment for customers who patronize the restaurant. Meanwhile, on the side of the defendant, they argue that A, there was no failure breach of duty by the defendant to provide a safe environment for its customer, and B, there was no evidence through any expert witness proving that the rises were in fact uneven. So the conclusion at the trial of the magistrate dismissed the plaintiff claim on the basis that there was no evidence through any expert witness to provide the rises were in fact uneven, and B, there was a familiarity with the use of the stairs by the plaintiff since he frequently visited the restaurant. But then, the plaintiff appealed, claiming the magistrate erred on 2 main points. First, she failed to recognize the defendant witness 2 as the owner of the restaurant admission that the rises were in fact uneven, so the plaintiff did not need an expert witness to prove it. And second, she failed to find that because the defendant witness 2 admit that the stairs were in fact uneven, so there was a duty on the defendant to provide sufficient warning, such as colored strip affixed to the rises. So the learned counsel for the plaintiff rely on the Australian case of the Convey against States of Queensland 2017. So moving on to the issues that related to tort law, which in this case, first, in terms of duty of care, in proving whether the defendant owe a duty of care to the plaintiff, which in this scenario, the restaurant, as the occupier is being looked, to see if it had a legal duty to keep its customer, including the plaintiff, safe. So whether the stairs rises were uneven. So as been discussed, the defense witness too, as the restaurant owner, admitted that the stairs were uneven. So there was no need to call an expert to prove the unevenness of the stair. So second, whether the uneven stairs are an unusual danger, as the plaintiff is someone who is familiar with the stairs, as he is someone that frequently visited the restaurant. So next, in terms of breach of duty of care, whether there was a breach of duty. The defendant had a duty to post warning to warn of the uneven height. So in this scenario, the defendant failed to provide any warnings which breach his duty of care. And last but not least, in terms of causation, whether defendant breach of duty caused the plaintiff to fall. So that's all from me. Thank you.
Bismillahirrahmanirrahim. Now we are moving on to the ratio decision section. First of all, we are going to look into the types of visitors. So the case has been referred to the Datuk Bandaraya Kuala Lumpur against Ongkok Bank and another. There are 4 types of visitor, which is contextual entrance, invitees, licensees and trespassers. So the customer to a restaurant is regarded as invitees. Now we're moving on to the duty of care. The court has asked 2 questions, which is, was the stairs uneven, and was the uneven stairs an unusual danger? The case that has been referred is Teh Ok Ki against Tan Chia Hock and Convict against State of Queensland case. For the breach of duty, the court has looked into 3 aspects, which is the state of the stairs, the state of the land, and also maintenance on the stairs. For the causation, the court has used the principles in the case of Convict against State of Queensland. Also, in this case, the defendant also used the defense of contributory negligence, and also this defense is referred to in the case of Hamizan Abdul Hamid against Wong Kok Kiong and another. Next, we are moving on to the decision made by the court. After taking consideration about duty of care, breach of duty, causation, and also contributory negligence aspect, the court had the plaintiff had proved that the defendant had duty to care, and the defendant failed in this duty by not warning about uneven stairs. However, the court doesn't blame only the defendant, but the plaintiff also been blamed for negligence, because even though the plaintiff is a frequent customer and he already used frequently the stairs, therefore he also negligent by voluntarily using the uneven stairs. The higher court disagrees with the magistrate's decision, and instead it decided that responsibility for the incident should be shared between the plaintiff and the defendant by the ratio of 70-30. Additionally, the defendant ordered to pay costs amounting to 3,000 ringgit to the plaintiff.
Now, for our comment, we does not agree with the decision of High Court, particularly on the part of contributory negligence, because we believe that the plaintiff liability should be less than the ratio of 70-30. This is due to the fact of the plaintiff fall was caused by the unevenness of the stair, which made him to misjudge the step and fell. This is why we think that the contributory negligence part should be revised in this case. If we look into the relevant case that could support our agreement, we will look into the case of Petrobelli against Jewel Family Nominees Limited, which is a case that happened in Australia in 2022. The material fact of this case are the same with our case, which is the plaintiff fell down the stairs at the defendant premises, and the dimension of each step of the stairs vary significantly, or we can call this as uneven staircase. Now, the defendant plead for contributory negligence because defendant argue that the plaintiff failure to exercise reasonable care toward herself on supported the finding. Now, just dismiss the submission of contributory negligence. Why? Because the judge said that plaintiff fall was caused by geometrically irregular step that confronted her, and she was not expected to adapt her gait to ensure that she was able to safely descend the stair, which means that in this case, the defense of contributory negligence failed because the plaintiff fall because of the defendant negligence, which is the uneven staircase. The same material facts with our case, and therefore this case could be applied and look further into during the trial. That's why we think this relevant case could support our finding that we think the judgment of contributory negligence should be revised. some other area of law that should be observed by the court is the concept of eggshell scar rule, where the defendant must take plaintiff as what he is. In our case, the plaintiff is an octogenarian with the age of 80 years old. Thus, the argument that said that plaintiff is also liable because he should get the assistance of others on going up the stair should be revised. If we put it in the context on another scenario, which is a blind man get hit by another person, would the blind man be liable because he should get assistance from others? Therefore, we think that the concept of eggshell scar rule must be applied in this case. That's about our area of law that should be observed by the court. Furthermore, the effect of this case, we think that from this case, the decision will serve as a reminder and also a stern expectation on occupiers so that they could maintain their building and also identifying and remedying structural defect and hazard so that we could protect the public from danger. That's all from us about our comment and also our suggestion and area of law that should be observed by the courts. That's all. Thank you.